Good afternoon, Judge Pillay.
Good afternoon, Chief Justice. I was looking for you
How
all
are you?
around.
How are you?
Sorry?
How are you?
I am fine, thank you.
All right, okay. I'll first travel slowly so that you can settle in the environment, and then we can take it from there. I noticed that you have not been indifferent to what is happening in the nation. You got interested in the efforts to help rid our country of apartheid. Tell us a bit about that.
Well, my practice started in that area of our law. In fact, in that time of our country, I started practice as an article clerk in 1979. And when I qualified, I had to help out at the firm of Paul David, who was at the time held up in the British consulate in protest against the apartheid legislation that was being mooted at the time. And then when he came out and went into trial, my partner was in hiding, Yunus Mohammed, and I joined that firm to manage the human rights and political cases that were heading to his court. Practice in that firm of Yunus Mohammed was a privilege and a great groundbreaking time for me and for the law. One of the judgments that we were co-responsible for, Curtis and Kondo, I noticed was quoted in the Barnard judgment, solidarity on behalf of Barnard, and the principle there was a right to a hearing before a person is detained. There are many other judgments that our firm generated at the time, including in the labor field, Sabia, the right to a hearing, and Lachisa Tsinoli, where we challenged the emergency regulations. Those are some of the highlights of that experience. Then President Mandela was released, and we were lucky to be in Cape Town at the time, visiting prisoners on Robben Island. Then came the drafting process, the second constitutional drafting process, where I was drawn into drafting clauses of the Constitution, particularly the election provisions. Then Minister Tito Mboweni appointed me to the Labour Relations Drafting Task Team that produced our current Labour Relations Act. And he appointed me also to the Essential Services Committee, the first that we've set up in the country. I had to set it up, establish the jurisprudence, and 5 years later, I was called to the Labour Court. And before that, I had a rich arbitration practice, private arbitration. And the thing about private arbitration is that you are called to help parties to resolve their disputes. So unlike us as judges, we're imposing people. Arbitrators are invited to help out in disputes. That's not the case in the CCMA, but private arbitration works that way. And for me, that gave me a huge amount of confidence. As a practicing attorney, I had advocates appearing before me, including senior counsel. I learned from the best in the industry at the time. But it also helped me with drafting. The strength or the reason why I had a thriving arbitration practice and dispute resolution practice was because I delivered my arbitration awards pretty much on the turn. And the same culture continued with me in the labor court. Well, as you know, labor arbitrations have to be delivered within 14 days. But in the labor court, we were moved around a week at a time. So 1 week it's Johannesburg, the next it's Cape Town, East London, Port Elizabeth and Durban. So if you didn't want to lug your records around, then you got rid of your judgments by the end of the week. So that also helped me inculcate a practice of getting my judgments out very quickly. It's also the good part of it is, well, my family doesn't think it's a good part, but I'm quite cranky until I get my first draft out. So after hearing every matter, the first thing I would reach out for is a dictaphone or a drafting paper and put down my formative thoughts and the direction in which I'm taking. This practice has served me well in the Constitutional Court, which I'll tell you about and how it's been modified. But then I migrated to the High Court. A very different experience, a very exciting experience also. And I looked at the DGRU's list of fields of law, and they've listed about 13. I think I've covered at least 12. Customary law passed my desk on one occasion. But what's not mentioned there is mercantile law, which I've also been exposed to. One of those judgments was quite a sizable amount involved, which I refused leave to appeal and went to the Supreme Court of Appeal, and the petition was refused. It was a case of a ship being damaged in Richards Bay. Then I come to the Supreme Court of Appeal. I was fortunate to have 2 terms there, and thanks to President Meyer for affording me that opportunity. It was another great experience, sharpened my skills in drafting, for which I am grateful to Muhammad Nafsa's metaphorical red pen. And that was, I'm also grateful that experience preceded the one I am now seeking appointment for. Then I'm currently acting in the Constitutional Court, and I must thank the Chief Justice for this opportunity. What really excites me about the Constitutional Court is the processes there. And I think my experience is different from others because it's been entirely under lockdown. So I haven't had to waste time at airports and lugging bags and records around. So it's been very focused on the work, reading, and tending to the inbox and our emails and writing. So what excites me about the Constitutional Court is the processes. There's a particular dynamic that comes from the processes we use at the Constitutional Court. Let me give you a brief description of this. So when a matter is set down, the clerks distribute amongst themselves. So there's 8 chambers. 8 chambers distribute 8 questions and prepare on those questions that may arise in the case. Then the scribing judge prepares a case note for a pre-hearing case note, which is circulated the day before the court hears the matter. And in that case note will be identified the issues that will or may arise in the matter itself. Then we have the hearing, and then within 7 days usually, the first post-hearing note must be produced. And that when that post-hearing note is produced by the scribing judge, it gets emailed to all the judges, and then each judge has an opportunity to comment on it. And that's the first level of the excitement, because you're looking to see how far away you are from the thinking of other judges. And to the extent that you're not on par on one or the other issue, you're thinking about how to bring about consensus around areas that you are not in agreement with, or how to avoid disagreement. And the second excitement arises when you put out your first draft. That would be after you've taken into account all the feedback you've got from the 10 other judges or whoever else is presiding, and to pull together a judgment that is persuasive, that wins everybody's vote, is another excitement. I'm still going through all these exciting phases. I can't tell you that I've put out anything yet, but it will happen soon. So this was my first term at the Constitutional Court. I am also extremely privileged, singularly privileged, to be able to serve on the Independent Electoral Commission. I am the judge commissioner there. The work has been extraordinarily rewarding. I get to see democracy from another end. I get to meet the most amazing administrators of our democracy. And one of this year has been particularly trying, testing. Well, as you know, last year was COVID, and so we had a mass phase of by-elections. But this year we are earnestly in preparation for the local government elections. We started the year with having to meet tight legislative deadlines, which we did. As you know, the Political Party Funding Act has come into operation on the 1st of April, and there are amendments to the Electoral Act, which we managed to get through. There's also the pressure on the IEC from the Constitutional Court's judgment on reforming or amending the legislation to enable individuals to participate in elections. So those timelines are pretty tight. And I'm happy to announce also that we are ready for the local government elections. That's what our CEO has been informing the public, and I'm happy to repeat that here. There are, as a result of the Constitutional Court judgment, which put the IEC on terms to attach addresses to voters. I'm also happy to say we are 94% up to date with addresses. One of the amendments that we effected to the legislation was to ensure that anyone who qualified as a voter would be allowed to vote if they were able to produce an address. We are still finalizing one or two things as far as the addresses are concerned, but the basics for the local government elections are in place. And yes, that takes me to summarizing that I have over 40 years of experience in a wide wide areas of law. I should just mention also that the 10 years in the labor court brought me to the coalface of socioeconomic rights, more so than the High Court did. In the High Court, it's very hard to get practitioners to practice constitutionally. Very often, judges have to point out there's a constitutional point. The judgment you have before you that the DGRU produced in the report on me, the case of Mr. Dlamini, the practitioner there is ever grateful that I raised with him the constitutional angle to what would otherwise have been a pure common law case where the person who signed the contract, Mr. Dlamini, would have been bound on the basis of the pacta sunt principle. And you simply need to flip through the Constitutional Court judgments to see that the constitutional point is raised for the first time very often at the Constitutional Court. And that's not how we want our practitioners to practice constitutionally. Academically, my highest qualification is a doctorate, which I got from the University of Pretoria last year. The topic is moving litigation from dispute resolution to problem solving and building organization. I was an extraordinary professor for about 9 years at the University of Pretoria. I'm currently such a professor at the University of Free State. I had visiting fellowships abroad at the university. In fact, I taught at the university, law school, Seattle Law School, the Open University, Oxford. I was a visiting professor there with several of their units. And at Harvard was my last sabbatical. So I've spent every sabbatical in pursuing some form of academic interest. And I owe this to my family. My parents were deprived of education. They didn't have the opportunities. And so it has been a mantra in our family that the best investment you can make is one that no one can take from you, the one that keeps on giving, and that's in education. So I continue with my public interest work as well. I gave the Victoria and Griffiths Mthenge lecture in 2013. And as we were waiting in the wings to go in to make the presentation, a friend of mine said, "Why don't you give an award like some of the other people are doing?" And there and then I decided to give an award in the name of my late partner. So this is called the Yunus Muhammad Public Interest Law Writing Award. I work with, initially I worked with the University of KwaZulu-Natal. It expanded to the University of Pretoria and now the University of Free State and Cape Town participate in the project. After 3 years, I mentioned it to Kagiso Capital, which is the investment arm of Kagiso Trust, at a function where they were honoring my late partner in the building that they were opening off the M1 in Johannesburg. And the CEO there, Gatso Skuman, said, "We would like to partner with this." In fact, what had happened when he passed away in 2008, a number of the trust, the investment companies, and some of the other corporates, FNB, I think, or First Rand, announced that they wanted to commemorate my partner along with other trustees, Beyers Nadir and Archbishop Tutu and so on, Max Coleman, in different ways. But it never got off the ground because we had the 2008 economic crash. And so this was the opportunity that Kagiso Capitals sees. They handled the funding, they put up the checks. I handled the academic side of things. I collaborate with the 4 universities. What is the competition about? It's about each university putting up published articles from that university. They make a selection of the best article and suggest to a panel. The panel consists of me as coordinator and the other one representative from each of the universities, and we choose the best article from that university, for which a prize of 5,000 rands is awarded. And there's different categories of publications. And then there's a national award, which we sometimes have had to get deal breakers. Malcolm Wallace helped us on one occasion. Frank Mickelman from Harvard helped us on another occasion. And so there's a national award. We have had, because of COVID, the first launch of the project was physical and in Johannesburg, and we had a number of speakers present and so on. But since COVID happened, we've had the winner of the national award presenting online to whoever tuned into the program. That's the Public Interest Law Publication Award. I have been invited and I've joined the board of Cancer, another very rewarding public service, very much under threat in terms of its financial ability to meet its demand through COVID, the inability to raise funds as it used to through the malls and so on. But we're getting there. Then, of course, Dr. G from SAJE draws me into different types of activities for SAJE and training and so on. Deputy President Petzer, one of the things that President Meyer mentioned at a previous session of the JSC was that a weak judge who takes time or has difficulty grasping the issues and therefore has difficulty articulating them in the form of a judgment, has a consequence that that panel is delayed, and the burden on the other members of the panel is increased. Now, we're talking about a panel in the Supreme Court of Appeal, but in the Constitutional Court, the panel is the court. And I am very mindful that I have to meet those standards of not drawing down or delaying the other members of the court, and to make sure that my feedback and responses are prompt. In terms of the challenges facing the court and whether I'm up to it, I think there are at least 3 challenges facing courts internationally. The first, I think, comes by way of the 4th Industrial Revolution. This is the most unregulated area of our life. We have fake news pervading our environment. We have misinformation. Elections have been won and lost on the basis that reputations have been destroyed as a result of that. So the pressure on the common law to develop where legislation is lacking is huge. At the IEC, during elections, what we have is a special unit to deal with fake news, to have a system where complaints are dealt with expeditiously because you can't wait for court hearings and so on those matters. But this is a very serious threat also to democracy, particularly where there's an interference with election results. But also the fourth industrial revolution has changed the nature of our economy. We need to recognize that we're no longer a commodities-based economy, whereas our labor force, unfortunately, has been predominantly trained to work on the mines and in the fields. That kind of, the current economy is going to entrench those inequalities, those pressures on socio-economic rights and for distribution. And so the pressure is going to be on the court again on how we exercise constitutional rights in favor of the population, those parts of the population for whom the Constitution is meant to exist. The pressure on the common law will test areas of law relating to privacy, to intellectual property, to dignity, and security, and a host of other untested areas of law. We are legislatively unprepared for it, I think. Australia recently tried to legislate against Google and Facebook to cause them to pay for advertisements that run on their platforms. And as a show of power, those two corporates shut down systems. But I suppose the happy end, or it's not necessarily the end, but the result of that is that they're in dialogue and in some process trying to figure out how best to regulate the internet. So the fourth industrial revolution is a big part of, I think, the challenge for all judiciaries. The second is the pandemic. We found ourselves having to make rules in a constitutional democracy on the back foot of the pandemic. And what rules we've made have yet to work their way through the courts to see how the courts are going to respond to that. The environment is another threat. And as more people become unemployed, the pressure on the environment, which is already strained, is going to increase. So again, the pressure on the courts, how do we deal with that? So the next, the last global challenge, I think, is that of constitutional crisis and backsliding. Now, post the Cold War, the Cold War brought the romantic era of constitutionalism. Constitutions became the flavor of the times. Everybody wanted a constitution. I think there's over 65, probably more, constitutions that came to be in the last 20, 30 years. Even England got a Bill of Rights. But what we're noticing now that constitutions are under threat. And I say this not as something that I imagined, but there's a book in which some 20, 30 countries have been surveyed, including our own. And they define what a constitutional crisis is and what constitutional rot is. Constitutional crisis, they say, is a situation where keeping disagreement within ordinary bounds of political discourse becomes impossible. Political crisis, a symptom would be where public office bearers announce publicly that they are not going to be bound by the Constitution, where public office bearers and people, I suppose, in general, refuse to obey court orders even when court orders, even when one disagrees with court orders. We know that under Section 163, 5, that we have to, 163.4, we have to obey court orders, whether we like them or not. Thankfully, our judiciary and our Independent Electoral Commission is a bulwark against constitutional crisis. We're nowhere near constitutional rot, which is a state where institutions are completely dysfunctional, where public trust in our institutions is non-existent. So we're nowhere near there. But it just shows Chief Justice and Commissioners how important this institution is that we serve. I'd like to pause here. Perhaps I should just say that the work that judges do is sometimes publicized on television, and it looks entertaining and so on. But the hard work, where we really grapple with stuff, is beyond the view of most people. And in reflecting on what is it that compels us to stay the course, I'm reminded of the health workers who, during the pandemic, came to work and worked to save our communities. Chief Justice, there were two things that came up in the reports. If you'd like me to deal with that now, I would deal with it. Otherwise, I'll wait for questions around those. Thank you.
I think wait for the questions. Thank you very much. Colleagues, may I have the names of those who desire to put questions to Justice Pillay, please?
Makwanisha,
Matonsela,
Mwimang,
Shlina,
Nyambi, Dodovu,
Nakiesi,
Malema,
Tete.
Lamola, Mlambo.
Thank you. Honorable Magwanisha.
Thank you very much, Chief Justice. Good afternoon, Judge Pillay.
Good afternoon.
Thank you. I only have one question for you. Is it true that you remain a director of two investment vehicles? And then if appointed, do you have any intention to remain a director of those two vehicles?
Thank you for that question. That's one of the questions I wanted to clarify. The one corporation, Beyond 1719, has been on my application from the year 2000. I explained then that it is a convenient vehicle in which my partner and I set up for my family in their retirement, not me, my parents, in their retirement. The assets in there is now two properties which pay rent, and sustain my family. The second close corporation I inherited from my partner, who, when he passed away 13 years ago, it houses equities listed on the Johannesburg Stock Exchange. That too I disclosed on the 2 previous applications for appointment to the Constitutional Court, which, by the way, I was recommended for appointment on that occasion. And when I applied for the Supreme Court of Appeal, in fact, on one occasion, Justice Minister Radebe had a joke about my close corporations. But Minister Lamola is here, and he can tell me whether he wants me to do anything with those. I could very well hold those properties in my own name, the shares in my own name, but it's a nuisance, and it seems to run itself, but hasn't interfered with my work. My judgments still go out. The companies I have in my portfolio have also been, the shares have been reported in the judge's registration every year. It's been there for everyone to see, and no one has applied for my recusal on the basis that I've got net bank shares or this or other shares. It's never interfered with my work. In fact, it's better out there, locked away in a close corporation, than my having to deal with it in my personal capacity. So I'm open to suggestions, and if elevation to after 20 years, holding these instruments, if that is a barrier to elevation to the Constitutional Court, it's not a problem. It can be dispensed with.
Thank you very much, Chief Justice.
Thank you, Honorable Mokwane. Commissioner Madonsela.
Thank you, Chief Justice. Judge Pillay.
Hello, Commissioner Madonsela.
At page 15 of your application, you refer to the Devon Constitutional Law Discussion Group, which you're a member of. And
I'm going to listen to you. I'm not going to find it.
yes, I know. Please, you don't have to look at it because I think you know what I'm talking about.
Yes, it's where we met first.
I wanted to explain to the commissioners what is that all about.
It was a group of practitioners and academics who came together and identified interesting topics, and one or other practitioner or academic would present on the topic, and we would have a discussion around it. And that's years ago. And Commissioner Madonsela, you were responsible for keeping it alive, and I must remind you, you have not done that.
It's still alive.
Okay.
Yes. How is that enhanced? Just a follow up on that. How has that enhanced your knowledge of constitutional laws?
I've always been interested in constitutionalism, and that was a wonderful opportunity to articulate all sorts of aspects of the Constitution. And often it would be a case that came out of the constitutional law around which we would have a discussion. There was no other platform. And as a judge on the Labour Court at the time, it was pretty lonely, and even lonelier in Durban, where you sat by yourself. So the opportunity to engage academically was quite a privilege.
The second question is relates to judgments, the delivery of judgments. I have the privilege of practicing in the courts where you are the judge. And I must state this upfront that of all the judges in our division, you are particularly known for giving your judgment very quickly. And when you go to your court, you get an answer very quickly. You know where you stand with the judge, which we appreciate. Now, the question is, we as a Judicial Service Commission, we encounter a situation where there are complaints about judges delivering judgment timelessly. And I'm saying this with all due respect. There has been I've noticed in recent times, because of my involvement in the Constitutional Law Reading Group, which I'm keeping going on in Devon.
You just haven't invited me.
Yes. I've noticed that some of the judgments in the Constitutional Court, where you are now sitting, and most recently one involving the Competition Commission versus Standard Bank, was delivered almost a year after it was argued. What do you think should be, or what do you think you could bring by way of, is there a process in which judgments can be delivered earlier in the Constitutional Court? Or why do the court judgments delay? Do you know?
The process, as I said, there is a process and there are timelines. And if it is delayed, it is because there are some difficulties that are encountered in terms of arriving at a consensus or exploring different ways of doing things. My experience is 1.5 months. So from February to now, I've been in the court, and we sat until the middle of March. So my experience is very limited to say, well, this is what needs to be fixed. But clearly, if we can get, the basic principle is that if we can get to to grasp the issues quickly and write clearly and coherently, and in fact, if we write, I suppose, shorter judgments, that might help. I know that the complaints have been coming about long judgments from the Constitutional Court. That's before my time, and it takes long to read through, correct, and give feedback. But that might be one of the reasons. But there is definitely a process. I know that we all commit to the process, and it is only when there's some difficulties that arise that one has to trade off time for the best outcome.
Chief Justice, just as a follow-up on that question, with the permission,
Yes,
Chief
sir.
Justice, my suspicion is that judges don't agree when they deliberate on matters before them, and that might contribute to the delay. And to what extent do you firmly believe in the writing of your dissenting judgment, even if it might cause delay? Delay versus delivery of the judgments quickly and conceding a point that is not of substance in your own dissenting judgment?
And there's a struggle, a really solid struggle to get consensus. And but we're independent adjudicators, and we have that tension to respect. And if it is an immaterial point of departure, you might concede it. But if it is material, you have to, after trying to get consensus, dissent. And that's honest to your conscience, because that's what we're there for, to be honest to our conscience.
Their licensing in terms of very general or so on actually.
Well, Mr. Chilwani, there's interference there. Please take care of it. Please proceed, Judge.
So dissent is not a bad thing. And I don't think one should look at dissent or being overturned on appeal necessarily as negative. I see judgments, dissenting judgments, and being overturned as opportunities, well, both for learning, but also opportunities for looking at things differently, opportunities for taking the best from both judgments, or for both sides, or as many sides of the debate that there might be. It's not necessary that every dissent is wrong or that the majority is wrong. And I think to say that a judgment is right or wrong is the wrong approach, because that's a binary. And in binaries, you miss out everything in between, and there might be a lot good going on in between.
Thank you, Chief Justice.
Thank you, sir. Honorable Mwema.
Thank you, Chief Justice. Good afternoon, Justice Pillay.
Good afternoon, Commissioner.
Just one question from my side, which is linked to the point that you raised around the readiness of the Commission to successfully deliver the next local government election. Indeed, the Constitution says the electoral process must, in general, result in PR. But of lately, given the directive by the Concord to Parliament to amend the electoral laws with a view to do away with our practice of saying that the only route to the provincial legislature and the national legislature is through political party vehicle, thereby ruling that independent candidates must also be allowed to represent themselves both in the legislature and national parliament. From your experience, do you think the timing is right for us to embark on such a drastic electoral reform? Thank you, Chief Justice. Thank you, Justice Pillay.
Well, it's not what I think. It's what is. The Constitutional Court has said that it's time to make this drastic change, and the IEC is really doing everything it can to accomplish that in the time frames, which are pretty tight. You would have heard that a task team has been set up by the Minister of Home Affairs, Ara Matsaledi, and the Commission is not a member of that team, but one of our colleagues is helping out with that commission. And we have to wait. There was a launch in Parliament of that task team and its work. And I think we must wait with some excitement, perhaps some trepidation. Certainly from the IEC, it's both, because as the administrative body, we've got to make sure that we deliver a draft. We're instructed to order to deliver the legislation. And I'm not exactly sure how we're going to navigate that. Because once we have a draft, it has to go through parliamentary processes of which you are better informed than I am. Then there may be challenges to the draft constitutionally and so forth. So the timelines are quite tight. And to answer your question, it is upon us. And the debate is over. We've got to get on with doing it.
CJ, just a follow-up. Look what the local government system, which is mixed, both ward and PR, where a ward candidate or a ward councillor passes on, by-election is possible. At a practical level, with provincial and national general election, when an independent candidate passes on, how from your conceptualization will we be able to deal with that difficulty?
It is one of many, many difficulties. To begin with, what thresholds do you set for entry to participate in the elections? Thresholds have to be one that you don't, it's not exclusionary. Setting a registration fee or the number of supporters, all of them have pros and cons. And those are the issues that we're working with. The question of when an independent demises, what happens? It's the jacket, as my colleague says. My jacket was there, and the jacket is no longer there. So what happens to that post? We've got to figure it out. And actually, when I say we, I mean we as a society. The burden of drafting falls very much on the legislature, and our input as the IEC is from a technical perspective as to what would work, what won't work, what could be done better. But very much we're not sitting back, but we're helping wherever we're invited to help.
Thank you, Justice Pillay. Thank you, Chief Justice.
Thank you, Honorable Moiman. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Judge Pillay.
Good afternoon, Commissioner.
Just on your comments on the new legislation, well, it's indeed going to be a daunting task, given the timeframes that we have, but it's one that we have to deal with. And you have mentioned some of the things that we'll have to really deal with and try and convince the courts that maybe, well, we can't question the decision of the apex court, but perhaps the reality of implementing what they have said is going to be something quite difficult. But having said that, Judge Pillay, I think you are aware of bodies, legal bodies, and other bodies that provide comments on each of the candidates that apply for various posts in the judiciary. And I think you were about to start commenting in your introduction to some of them. And Commissioner Magwanisha dealt with one of the issues that was raised by the Law Society of South Africa. Now, in addition to that, I see the Law Society raises the issue of your participation in NADEL, and I think you should be given an opportunity to respond to that. But in addition to that, they also say that you've had experience in the labor court and not much elsewhere. But I note you've had 10 years in KZN. But you can respond to that criticism as well. But also there are letters of objections that have been sent to us by 3 individuals. And the objections relate to judgments you've given in particular cases. I think you would have read that. And one also refers to a possible conflict of interest in one or two of the matters that you presided over. Now, I wonder whether you would respond to those comments, adverse comments that have been given, but also to say that there have been positive comments from advocates for transformation supporting your candidacy, from the GCB to say that you are suitable. So I think it's an opportunity for you to respond to those objections that have been sent through to us. Thank you.
Thank you, Commissioner Singh. Yes, the one, the first concern raised was my membership of NADEL. Now, that information you would find in my very first application for appointment in the year 2000, when my partner was alive. And I'm going to blame him for this because we tried to figure out when NODEL was formed. And I'm just trying to think back how it came to be that I put in 1984. What I do know is that the year I started articles was the year in which the DLA was being mooted, 1979. The Democratic Lawyers Association was spawned as a result of the Magistrates Court being launched in Durban late 70s. It had segregated entrances and so on. And so the practitioners protested, and DLA was being mooted at the time. Pretty soon, the other centers, Cape Town, Dalla Oma, Johannesburg, Ismail Ayub, Kachalia, and in the Eastern Cape, in Sabeza, Dumisa and Sabeza, all started thinking about having branches or organizations for lawyers. And it was edging close also to the formation of the United Democratic Front in 1983, and which was followed by the emergency regulations, states of emergency. And the lawyers' body gained traction then. So at some point, these individual bodies morphed into NODEL. And I might have the 1984 date wrong. I know that when I Googled, I see that NODEL was formed in 1987. But I was an active member, practitioner in amongst lawyers. I served with Pius Langa and Linda Zama on a subcommittee of NODEL after it was formed. And I don't think the questionnaire is challenging my integrity about whether I was involved or not. It's just that I assumed that NODEL had been formed as branches beforehand, before it was launched in Riverside Hotel in 1987. So that's the explanation for NODEL, and that mention of an incorrect date. Then there's one person who, Ramkasoon, I think his name is, who wrote to the JSC saying that I shouldn't be appointed and all sorts of things. But that person actually applied to the Constitutional Court during my term there to have his case, the decision I made, overturned. And of course, I recused myself. And the unanimous view of the court was to refuse leave to appeal, jurisdiction not engaged, etc., but didn't grant award costs against him, and that was it. There are other people who liberally comment about judges' decisions in the media, and everybody knows that judges don't respond to media statements. People who have a gripe with judges, there are platforms to raise them. The JSC is a platform. It's getting pretty active at doing, at supervising the judiciary. So anyone who has a complaint, put it before the JSC. We'll deal with it. That's what it means to abide by the Constitution, abide by the rule of law. We can't respond to noise out there because that's just what it is. But it is damaging. It is damaging, particularly to women, when misogynistic messages hit the media. And if those women are judges, are mothers who have to put up with that, then Chief Justice, you asked me on a previous occasion, why is it that women don't make themselves available? If they have to put up with the risk of being abused of things that don't matter, that are aimed purely at interfering with our work, why should mothers put their families at risk? Because the judge can take care of herself, but her children are out there in school, perhaps teased, but worse still, threatened. So this is a very dangerous practice that our society should not allow to burgeon. We need to put a stopper. This is a sort of digital information disaster or side effects that's not helpful to our society. Conflict of interest, if ever there's a conflict of interest in which I am in a matter in which I'm presiding, then it is up to the person who perceives that there is a conflict of interest to apply for my recusal. That too is a process recognized by the Constitution, recognized under the rule of law in every judiciary. I've hardly had any applications for my recusal. So unless an application is made, unless I feel conflicted, then there's no application for recusal. The other thing to remember is the Safu judgment. When Louis Late brought an application to have late President Mandela testify, that application, well, to testify, but I think more to embarrass the president, because his evidence in chief was half a page and his cross-examinations extended over 150 pages, but that's by the by. But the application was prefaced by an application for recusal of 5 judges of the Constitutional Court. And it was left to the conscience, apparently, of the remaining judges whether they should continue to sit. Now, there are troublemakers, detractors from our democracy, and we should stand firm if the judiciary is going to remain the bulwark against a constitutional crisis, constitutional right. Thank you.
Thank you. Judge Pillay, Chief Justice, through you. You've referred to the Ramkissoon matter. But in the book that's given to us, Feedback from Law Bodies, book 2 of 2, I don't know if you managed to read the letter from Mr. Malusi Mokhale, which is labeled as Objection 1.
GCB. Commissioner Singh, it might just be easier for you to tell me what it is.
Okay, through you, Chief Justice. Malusi Mokhale, I'll just give you the opening sentence and what he says in the end. He wrote to the JSC, I think it would be wrong to appoint Judge Daya Pillay to the apex court in the land. I was not convinced by her legal reasoning in the latest court judgment involving President Jacob Zuma. And then in the end, he says, lastly, putting her on the apex court where you need a rational, unbiased judge, where decisions of such court have fundamental impact on the lives and the lives of our nation, will be a grave mistake. Now that's Malusi. Then Mondi Duba writes on February 14, I want to raise my worry and concern about Judge Daya Pillay being shortlisted and likely to get the job to be in the Concord panel of justices. And then he ends up by saying that I hope and trust that my genuine concern will meet your attention. And then we have a third objection here from a student who calls himself a student, Mr. Simpiwe Mlotshwa. And Mr. Mlotshwa here also appreciates the opportunity. He's watched the interview of Judge Pillay before the JSC on YouTube, and he asked whether the Honorable Judge Pillay still holds the view that politics is in important cases before her ladyship, like she alluded when she was a candidate for judgeship in the SCA. And then the last three lines, is the Honorable Judge a friend or a close acquaintance of Mr. Hanekom? Is the judge a friend with Mr. Godan, Minister of Public Enterprises, or a close acquaintance? Does she feel that she needs to recuse herself on matters where litigants may perceive conflicts of interest or some bias on her part? I thought it's important for you, Judge, to respond to those objections and comments. Thank you.
Okay. Well, there's two matters in which Mr. Zuma was a litigant before me. I'll deal with both. The first was the civil matter, which Mr. Hanekom brought in the Durban High Court. That case was assigned to me. I was told that I was a senior judge, and I had to, a senior available judge, and I had to deal with it. If I had a choice, my preference was not to deal with, to have one of my other colleagues deal with the matter. But I was told that there's no conflict of interest, and there was no conflict of interest, and I dealt with it. The reason I hesitated to take on the matter is, besides having allocated that Friday to do other work, I had recently been hosted by by the former president at his Nkandla home for lunch, and it seemed a little bit discourteous to be presiding in a matter. But that's anyway, I got to deal with the matter. It was a common law dispute, defamation. And that's the law I had to apply. But knowing the parties, and I didn't have to read anything outside the pleadings. It was all there, founding affidavit, answering affidavit. It was all there. The politics was there. They were both members of the governing party. They were at war with each other. And what I recognized in that process was that I could resolve this dispute as a defamation claim and say, yes or no, Mr. Zuma defamed Mr. Hanekom. What I saw beneath that was a problem that I was never going to be able to reach. The source of the conflict was way beyond my competence, knowledge, and it was not a matter before me. And that diagnosis I was able to make because of my years of experience before I came to the bench as a resolver of disputes, mediator, facilitator, and so forth. And so that was the first judgment I made, and that's why I prefaced, because there were questions about why did I quote Oliver Tambo in the opening lines. And I thought that if these protagonists won't appreciate my judgment, then at least they must appreciate the utterances of their own leader. And it happened also that I was reading Luli Kalinikos's book, biography of Tambo, towards my doctorate at the time. And so it was fresh in my mind, and I put it there. And it's something I do in cases where I sense that the parties could benefit from some other insights about effective conflict management, not just dispute resolution, but conflict management. And I included it in a dispute. I've listed the case on where a servitude, two parties were fighting about a servitude. The second judgment in which I had Mr. Zuma as a litigant, again, was thrust upon me unexpectedly when I happened to be the senior judge in the crime court in Pietermaritzburg. I was told, like I was told with the Hanekom matter, that it's probably that the matter will be adjourned. And in the Hanukkah matter, when the parties pitched up in the morning, we're ready to roll, and so the matter proceeded. Similarly, in the criminal prosecution of Mr. Zuma, I was told this is just for an adjournment to arrange a date or something like that. And so I turned up in court and found that Mr. Zuma wasn't in attendance. The normal thing a judge does when a litigant fails to appear in court is to issue a warrant, and the judge has a discretion to stay the warrant. And that's exactly what I did. I stayed the warrant. There's no conflict of interest in those matters and the current matter serving before the Constitutional Court. And I'm very mindful of what I say here so that I do not disqualify myself from hearing matters in which litigants have already passed through the courts before me, as they might continue to do going forward. Because then we might be facing a Louis Late situation, and anyone who loses in litigation has simply to make a noise in the media, and judges can't be disqualified on that basis. That would be setting the absolute wrong precedent, and that would put our judiciary, this august body, in jeopardy. So that's the second thing. Am I friends with Mr. Hanekom? No, I'm not friends with Mr. Hanekom. I saw him in my courtroom on that day, and I know that it was him only because I've seen him in the media. Mr. Gordon, I've known Mr. Gordon for a very long time. We're both from Durban. We're both activists from Durban, and it's hard not to know Mr. Gordon. I think that's about it, Commissioner Singh. Have I answered all of your questions?
Yes, thank you. So in conclusion, you say in your view, these allegations of conflict, etc., are unfounded as far as you are concerned?
Completely, Commissioner Singh. The thing is that the calling of a judge is a very intense calling, like it is, as I said, for health workers. And it's very difficult to be true to the profession, to be true to the law, to be true to the Constitution. Deviation is hugely disturbing. And really, I'm completely, I was, as I said, I was party to drafting the Constitution. It is the baby that we produced. And long before that, when we, as activists, stomped the streets of the townships, mobilizing people to organize themselves and to fight for democracy, well, this is a democracy we got. This is the Constitution we got. And we've taken an oath to defend and protect it to the best of our ability. And that's what I am committed to doing. Nothing that I have done, nothing you will see in my judgments will suggest otherwise.
Thank you, Chief Justice.
Thank you, Honorable Singh. Professor Shlema.
We didn't hear that, Chief Justice.
Oh, I called on Prof. It's a turn.
Oh, okay.
Thank you, Chief Justice. Good afternoon, Judge. I would like to ask you a couple of questions on your link between academic life, your research, and being a judge. And specifically, I'm fascinated by your PhD or your doctorate that you did. I think the work that you've done in there is quite fascinating and can lead to quite a number of interesting follow-ups by hopefully others that will read it again. I see that you wrote there, and that is something that I also find when one reads a judgment and that you critique it, that you say here, critique of judgments tends to leave one with overwhelming impression that fault lies with judges or that litigation has to be rejigged as a process. but then you link it also to the participation of the litigants and their representatives. Would you like to elaborate a little bit on that so that we can have an understanding as to the impact that the litigants and their representatives have on the outcome of a judgment?
Yeah, well, you've heard time and again that the process of adjudication is a presentation of the evidence and argument and arriving before an independent, impartial judge, adjudicator, who will render a reasoned decision. So that's the format, that's a formula for adjudication. But what goes into the evidence is a choice that the litigants make. How to formulate the claim, whether it's an application, whether it's a review, whether it's an action, is a choice of the litigants. And their lawyers. The litigants choose the lawyers also. So there's huge space for choice. And judges are bound by that, what comes before us, what we call as the legal materials. But when I started the doctorate, I thought, as I said, that maybe litigation needed to be rejigged so that maybe you add on another process, tag on like mediation before litigation, like we have med-ob and so on. But when I got into the process of reading, I realized that if you're going to rejig litigation, then you're going to have to call it something else, because there's something very dynamic, and I wouldn't say pure, but something very dynamic about the process of adjudication that we must not lose. And that is that argument for and against a position is a wonderful thing to be part of, to hear and to analyze and to make a finding as to which is a better way of thinking about the issue. But regrettably, we live in an unequal society, and we don't have parity of participation. And so very often the court has to come to uplift that side that is flagging. And it's usually the side that is underrepresented, has very little resources, and so forth. I've been criticized in at least 2 judgments, one by the Supreme Court of Appeal, for sticking my nose beyond where I should have, and by my colleagues in the High Court. And my answer I gave in a previous judgment exactly about this, parity of participation. How do we get the best jurisprudence when we don't have the best representation for one or other side? But so coming back to this question of choice, judges also exercise choice. And what is this extraneous thing that influences choice? Because we're bound by the legal materials. But in every case where there is, say, 5 facts, 2 principles of law, and 3 judges or 5, 7, or 11 judges, you could have as many permutations of fact to law resulting in judgments as there are judges. But you can't say that those are wrong or right judgments, because they are judgments as defined, meaning the application of law to facts to result in a reasoned decision. So what is it then that informs how judges choose facts to law? And I think this is where our worldview comes into play. How we think about gender rights, racism, how we think about the economy, how we think about everything that's important in life. So that's our worldview, and it's crafted by our life experiences the choices we've made in our lives, a host of other things. I hope I've answered you.
Yes, you have. And I just want to follow up. I've asked the other candidates as well, the role that scholarly judgments play. When I read excerpts from your thesis, it seems to me that the scholarliness of the judgment may sometimes also depend on the argument that came before you. To what extent do you think you as a judge have an obligation to do additional research to ensure that your judgment is scholarly so that you do provide the necessary answer to the litigants if they do not, for instance, have the best legal representation?
Scholarship, I think, has been just part of my life. Once I've known a little bit, I needed to know a little bit more. And also there was a bias against attorneys coming to the bench. And so it was always a challenge to overcome that. And being an arbitrator helped a bit. But scholarship is partly about explaining things to oneself in the first instance, knowing that you've got it right. And you've got it. You've looked at the arguments for and against, you've looked at articles for and against, you've looked at cases going this way and that what you finally settle for is what you're comfortable with. And then the next challenge is to present that in a way that the readers, particularly the litigants, are able to access it easily. So legal writing and not legalese, it means writing clearly, concisely, and precisely, and communicating complex ideas as simply and effectively so that the litigants can develop from there, the practitioners can develop from there.
Thank you very much. Thanks, CJ.
Thank you, Prof. Honorable Nyambi?
Thank you, CJ. Afternoon, Judge.
Afternoon, Commissioner.
My question is linked to the one that has been asked by Commissioner Singh. The issue of the support from Advocates for Transformation. They raise that sometimes you appear temperamental, but they are supporting you. But when you're responding to the first objection about the issue of the former president, the one that was read by Honorable Singh, he touched the introduction and the conclusion. Once you read the letter, it's explaining that part of what was raised by the legal team representing former president, there was an issue of a medical certificate coming from a government institution in the form of a military hospital. And you were in a rush. So they talk of lack of empathy and humanity in how you handle that issue. So I thought when you have the opportunity, you were going to touch that issue of the letter because that's where this issue of lack of empathy and humanity, and those are attributes of a good judge. Your comment on that?
Well, I think you would have heard the hearing was televised. And the reason why I questioned the medical certificate was because of the alterations in them. So it had nothing to do, it's what I would do with any litigant. If, the court sees medical certificates of all kinds, and sometimes the medical certificate will read, the patient says he's unwell. Now, it's for the doctor to say whether the patient is unwell and what is wrong. But this had alterations. Now, that's my concern. And I did exercise my discretion in favor of Mr. Zuma in the sense that I did not authorize the issuing of the warrant immediately. I stayed it because that's what we do. And Mr. Zuma was not a flight risk. So I did exercise my discretion judiciously. I trust I've answered you.
What is it that you might regard as your own weakness?
I'm sure I have many, and the DGRU has identified one for sure. They called me a sledgehammer at my previous interview. I don't cut through butter like a hot knife, meaning as a metaphor that I suppose that I could develop my diplomatic skills a little bit more. And yes, that's true. That's one of the criticisms that came up, and yeah, I'm sure I have others.
Through you, CJ, I was expecting something that is coming from you, not the one of DGRU.
Oh,
your own weakness that you regard as your own weakness.
I know I mentioned it because I identify with that criticism. And, it's not just the DGRU who's raised it. It's also my friends who tell me that, I could rush into things and express my views rather robustly on occasion instead of soft pedaling and being a bit more gentle.
Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Honorable Dodovu.
Thank you, CJ. Good afternoon, Justice.
Good afternoon, Commissioner.
Good. In the public discourse today in our country, there is a talk of judicial dictatorship. And as I observe it, it is coming up very, very strong. Now, this afternoon, I just checked what is dictatorship in a dictionary. It says it's absolute authority in any sphere, intolerance, and imposition of power and authority. Do you, as a person, believe that there is an emergence of judicial dictatorship in our country? And what does it mean in the context of our constitutional democracy?
Thank you, Commissioner. There's a book called Towards Juristocracy that I found useful. And basically, what juristocracy is a condition in which the judiciary wields more power than the other arms of government. Now, the judiciary doesn't decide cases unless they're brought to it by the other arms of government, by the people. And the difficulty for the judiciary is, accelerates when there is a lack of common purpose and reciprocity in society. When people find it very hard to arrive at consensus about things and constantly run to the courts, to ask the courts to make decisions that they should really make themselves, then the litigants are giving the courts more power than the courts even want. The courts, Justice Froneman made this remark, I think it was in the Sausage judgment. It is the crisis in government and in institutions that burdens the courts. It's not the courts that chase judgments and seek power for themselves. So the one way that happens that juristocracies are created is when society is unable to resolve its conflict amongst themselves without judicial intervention. The other is when the court is packed by the appointing authority, by persons who would espouse the values of the appointing authority. But there's a danger in that, because today person X appoints a judge, there's no guarantee that that judge is going to make decisions favorable to that person or that interest, and vice versa. There's no guarantee that that person who made the appointment is going to remain in power as the cycle of democracy changes. But there's a third element, and that is that judges have a class interest. All of us are educated, we have to be. And many of us have better education than others, have come from better economic circumstances than others. And when we choose judges, yes, we must, the Constitution says, have regard to race and gender. But elitism is a phenomenon that we need to watch in the judiciary. So it is protecting constitutional rights that is foremost, and that must be the agenda. Elitist interests should not be encouraged. And that's when you get juristocracies.
Okay. Linked to what I'm asking you about, there is a talk of other tendencies that are beginning to manifest. For example, people are saying that judges in South Africa today think that they are above the law, they are above reproach. There is a modicum of encroachment into other spheres of government. And then where I see it, should I be worried? Just today and yesterday, we heard of something that is worrisome. A top 6 within an institution like the SCA. Where I see it, should I be worried that when such things are emerging, because top 6 to me is a cartel. It is an infection. It is toxic. Should I be worried where I see it that things are okay and the judiciary is on top of the world, is okay, there is nothing wrong, and they will preserve our constitution. And as you say, it is a bedrock of our constitutional democracy.
Commissioner, I think all of us have a lot to worry about. Well, I mentioned some of my concerns, and it is a deep concern that we don't dialogue as much today as we did when we drafted the Constitution. It's amazing that we've had this, what is regarded as a peaceful revolution, with the acceptance of our Constitution worldwide recognized and so on, that there's such a high level of disagreement amongst us. As for the top 6, I heard about it. So I went prepared when I went to the Constitutional Court. I said, I'm going to put my head down and draw the best I can out of this experience. And I did. There were minor skirmishes, and thanks to Rami Matopo, whom you've heard earlier today, he was a blanket of comfort. I called him my social worker, and he paved my way, and to the extent that the experience was overall positive.
Okay, thank you. Lastly, Chief Justice, and I'm linking this with the questions that I posed to you earlier. You are part of the electoral court. You are a judge
Commission.
Electoral court.
No, I'm not on
Are you not part of the electoral court?
No.
Okay, if that is the case, I stand down my question. Thank you, Chief Justice.
Please add my name.
Thank you, Honorable Commissioner Nogesi.
Thank you, Chief Justice. Good afternoon.
Chief Justice, is my name there?
Oh, it's your name.
You are next, Honorable Malema.
All right.
You come after him.
Chief Justice, Chief Justice, Is Cyril Xaba? May I request that you add my name as well, just a follow-up at some point? Thanks.
All right, I will include you, sir.
Justice, these questions have been dealt with extensively by Honorable Singh and Mr. Nyambi. But there's just one other objection that I'm not sure whether you have seen, this one of Avinash Ramkistan. Yeah. Well, I mean, it's the language he uses which concerns me. For instance, where he says, I mean, referring to you, I mean, in paragraph 2 and 1, so, one who we accuse is also in the business of being a prepaid judge. One whose name is also found on the CR document, CR17 document. My question is in relation to this. I know, because we don't have evidence. How do we end this thing?
How do we end?
How do we end these, whether it's rumor or whatever, because here is every time this thing emerges, and it's now emerging that you are one of the prepaid judges, you're in a document. How best this can be dealt with in your own way?
Well, I think set up a forum. Conduct an inquiry, put up the evidence, call us to account. That's when we will deal with it. I can't respond. No judge can respond to media statements. And as I mentioned earlier, Commissioner, litigants who lose are the ones who complain to the JSC, as you would know.
Yeah.
And for every losing litigant who makes a noise on the media, for the judiciary, for the leadership in the judiciary, for the JSC to react, it's not right. And to react means, and to act on it, means that we are confirming that those detractors are interfering in contravention with the Constitution, with the judiciary, whereas everyone, organs of state, must help the judiciary, Section 165, and must obey the laws and court orders, even if you don't agree with it. That Mr. Ramkissoon appeared in my court unrepresented, and in motion court. And practitioners here would know he was first on the roll. He came up as an urgent, and he started. And I said, Mr. Ramkissoon, I have this courtroom of people waiting to be heard. How long do you think you're going to need? Oh, I'm going to be here the whole day. I said, well, that won't happen. I have to, if you want a whole day, it has to be arranged elsewhere on another time. But how long do you think you'll take to get your point across? Half an hour. I sat quietly. I heard him out. I made a decision. His papers were horribly in a mess, which was confirmed by the Constitutional Court.
Yeah. No, okay, no, it's fine. This the last question is. It's just I follow up from your statement. You said you attended a function of President Zuma, I mean, former President Zuma. Was it at his, I mean, at Nkandla, I mean, that's how I understand. Was that at the, I mean, during the time when you were a judge, when there are these disputes? And what is your relationship with former President Zuma? What is your own relationship? I think that's my only question.
Okay, as the IEC, I get to meet the previous presidents as part of IEC work, and that is in the context in which he hosted me and another commissioner at his house. But my relationship with Mr. Zuma goes back into the days when he was in exile. He facilitated my visit in search of a friend of mine, the late Pillay. He was very gracious, and he ensured that I was met at the airport. He came to say goodbye. So my relationship with him has always been affable. He's an amiable person. And even after he became president, I met him at the budget speech. And so I have no personal truck with the president. I just do my job. And I am a disciplined member of the judiciary, and I have to be after 21 years.
But these allegations now of conflict, if you have such detailed relations in the eyes of a public man, somebody from the public, don't you think that they have some merit? But that's a question for another day. Thank you, Chief Justice.
Yes, Commissioner, it is a question for another day, but in court.
Honorable Malema.
Thank you, CJ. You'll have to indulge me. Afternoon, Judge.
Afternoon, Mr. Malema, Commissioner Malema.
Do you think that it is correct for a judge to look up to a politician for a decision whether to be in business or not? A judge that is applying for the highest court says to us here, a minister will tell me if I must leave business or not. Do you think it's correct to even say that?
Oh, I think the Act requires the Minister of Justice to approve the holding of any other office or source of remuneration. The Minister can confirm that.
But for you, morally and otherwise, we just heard here that you have listened to a case of that involves Standard Bank. And we hear in the same spirit that you've got shares in Nedbank. You might be biased in a sense that the decision you take on Standard Bank will have implications on Nedbank, and it can therefore influence or affect your shares. Looking from a distance as a layman, what must I make of you with such interest in business?
Well, I don't have an interest in business. I think if you go around and ask judges, many judges have investments in many institutions. And if you look at the registry of judges' assets, you'll find those disclosures there. I have shares in Standard Bank, I have shares in Nedbank. And so punishing the one or the other is not going to make any difference. In fact, they're furthest from my mind. And in fact, the judgment against Standard Bank, it never crossed my mind that my shares would be affected at all. You know, Mr. Malema, this issue of judges and their judgments affecting the share price was actually very much more topical when we were in the labor court, because a judgment saying that a strike was lawful or unlawful had a big impact on how the company operated. This is insignificant, and I think most of us have retirement annuities, and one way or the other, our pensions are invested in the PIC, which in turn holds shares. So the proximity of my decisions to these entities is just so far removed that it's not an issue.
You might understand that not to be an issue. The banks have become a big problem in this country. The banks have become too powerful in this country. And for a layman who litigate against banks, which in most cases win against us, and sitting from a distance and knowing judges have got shares, worse in all banks, because you even went beyond, now you've got 2, 3, Nedbank, Standard Bank, and all of that. Banks win cases against us and judges have got shares in the banks. It doesn't matter whether it affected your judgment or not. Justice must not only be done, it must be seen to be done. I'm sitting in a village in Mkomeni, in Butlokwa, in Limpopo, and I hear that judge who presided over my matter against the bank actually has shares in the bank. What does it do to my brain? I've got no education, I've got nothing. I don't know how it works in terms of shareholding or being a business person in the banks, but we just know business to be shares. You've got shares in the banks, you preside over matters that involves banks, and you rule in favor of banks against ordinary individuals. Does that help to enhance the good image of the judiciary?
Mr. Malema, I think the practitioners in my division will tell you how I lambasted the banks. Standard Bank, for instance, comes to the High Court with a claim for 10,000 rands repeatedly. 10,000 rands is the cost of hiring an advocate. Why are they litigating in the High Court? The reason I get is, or the explanation that I get is that the banks are chasing returns. So they have a panel of attorneys, and you got to perform, you got to deliver. And so the more you litigate, the more revenue you bring for the banks, the more you are used. But it doesn't cut it in my court. They also litigate for amounts that should actually be in the courts below, magistrates court, district courts, and so on. And I have repeatedly transferred matters there, and I've invited them to take me on appeal. I've given them 6 reasons why they should not be in the High Court. Of course, that increases the cost of litigation. In the 2 matters where there was this 10,000 rand claims, the litigants were, in one instance, in Port Shepstone. The case is being heard for 10,000 rand in my court in Durban. And they were expected to make that decision. They can't pay their debt, let alone get to a court. So I can assure you, if assurance is needed, that the banks really don't think I'm their friend.
Judge, you see, that's the problem, because we are now being extremely subjective because of your involvement with the banks. I'm saying to you, and we have to get this point very clear, not you. Remove yourself and your shares and your interest from the bank. I'm saying to you, would it be in the best interest and in the good image of this judiciary to have judges having shares in the banks and ordinary people litigating with banks and losing? We're not saying you are judging in favor or not, but we know in most cases our people are losing against the banks because they don't have the muscle to fight the banks. And they later hear that actually the judge so-and-so, Judge Mpofu, is a shareholder in the banks where they were litigating against. Will that help to enhance the good image of the judiciary? That's what I'm talking about. We're removing you now.
Commissioner Malema, I think if you look at the JSC, where most of our investments are, all of the corporates are in one way or the other infringing on one or other rights of workers, of the people, because these entities are in the business of making profit, whether it's Vodacom or MTN. The complaints about, well, the Constitutional Court had a Vodacom decision to make, but data pilferage, abuse, all of that, big companies, they do it. So whether it's a bank or whether it's a utility, whether it's a mining company, all have skeletons of one sort or another. So if someone can find a safe place where our money can grow for our retirement, our RAs can be invested, I think we can all rest more comfortably. But we can't manage our money. We can't be in business and make our money grow. We have to put it into fixed deposits otherwise and hope that inflation doesn't eat it up. But that's the state of play. And if there's a collective decision that we must not invest in particular entities or in particular forms, I'm happy to abide by the collective decision. But
Well,
there we are.
I take it you're not going to answer my question. I heard someone of the lawyers saying there's something called evasive. So there's something that sounds like that. Let's leave it. Is there a picture of you and Hanekom and Godan circulating?
You mean together?
Yeah, together.
I've never taken a picture with Mr. Hanekom.
Do you have a picture with Mr. Godan?
It's possible.
What's
But
your
I'm not
relationship with
circulating
Mr. Godan?
I've answered that I'm a friend of his. We've been friends.
Do you think it enhances the good image of the judiciary to have judges befriending politicians?
Unfortunately, it's not a relationship I can dissociate myself with, for the simple reason that he has been my friend from a long time, and I cannot deny that. It's never, the fact that he's been in government has never interfered with my adjudicative work. And he and I recognize boundaries. Politicians recognize boundaries with the judiciary. In the IEC, I interact with many politicians, and there are boundaries.
Judge, when you interact with us in IEC, you're not our friends. We're not friends.
I know.
Yes, I'm talking about friendship, and you shouldn't deliberately distort what I'm asking about. You are a friend of a politician called Pravin Gordhan, who is alleged to have captured judiciary. And I'm asking you, does that help to enhance the image of the judiciary? And you never answered the question on your practices, whether these practices are helping to boost the confidence of our people on the judiciary. That's what I'm asking about.
Okay. So if that's the part that I've evaded, I thought I had answered it. My answer is that I don't think, I don't know enough. But if somebody sitting in the rural area has the interest in my holding shares in Nedbank, I seriously doubt it, because I think my work as a judge should not be determined by what shares I hold. But if it is a problem, we can talk about that. As far as Gordon capturing the judiciary, as you say, it's allegations. If there's allegations, they must be tested, put up the evidence, bring it to a process, let's investigate it. I'll be happy to participate. Allegations out there is just allegations. Sorry.
No, I'm saying you being a friend of a politician, does that help to boost the good image of the judiciary? I'll tell you why. There are judges that I've known from when I was young. And when they got appointed, I disassociated with them for their own protection and for the protection of the judiciary, because there shouldn't be a story that they are friends with politicians and therefore they conduct themselves in this or in that way. And you are saying you will never terminate your relationship with Gordhan because it comes from a long way, even if it damages the good image of the judiciary, because from that friendship, an impression can be created that Gordhan is influencing you and you are influencing others to rule in the favor of his faction.
Commissioner Malema, you asked me what my relationship was. And in the broad nature of defining a relationship, I use the word friendship. Yes, we have been friends, but my association, and it's never impacted on my work as a judge for the past 21 years, and it will not impact on my work going forward. I've made judgments against the Treasury. I've made judgments against SARS, and it's never been a problem. But friendship doesn't necessarily mean that I'm having breakfast, lunch, and supper with Mr. Gordon. Our association has drifted over the years, precisely because, well, COVID has also been part of it recently, but over time, the two of us, when I spoke of boundaries, this is what I mean. My association with people who have been my friends, who are now politicians, have distanced themselves from me precisely for this reason. They don't want to compromise me. They respect the judiciary. They respect my role in it. They want me to be in the judiciary. Many of them have supported me in this endeavor in this application. And so they know where my heart is. And they know that my heart is not with politicians, but my heart is with the people of South Africa for whom this constitution is meant to serve.
I didn't get the impression first time because I thought the constitution was coming after the relationship with Gordon. Thanks for the clarity. The other question, after the lunch with President Zuma and going to preside on his matter, did you declare to the parties involved that you had a lunch with President Zuma? And after declaring to the parties involved, did you declare in the public court for us, the public, to see if that will not be a problem for us? Because you cannot go and have a lunch with a person and before you know it, you are hearing a matter involving the same person and you don't tell us, because I want to tell you now, if I knew you had a lunch with Zuma and you declared it publicly, I would have made an agent application to join that court and ask for your recusal, just for that reason.
No, quite right. If I was in a social engagement with Mr. Zuma, I was having lunch with him as one friend to another, I would have disclosed it. I was in an official engagement, and as part of my official duties, I didn't think it was important to mention all my official engagements. It's a matter of public record. And I would have assumed that Mr. Zuma would have instructed his counsel to apply for my recusal, if that was a problem. I anticipated an application for a recusal for one or other reason, but both parties were very happy to have me. And in fact, there was a high level of collaboration by both counsel with each other in the proceedings. They made my work infinitely easier because there's no dispute of fact. There's no dispute of what law applied. The issue was for me to decide whether this appeared in the tweets, I think it was. And this having been said, does it amount to defamation? That's all I had to decide. And that's what I decided. Both parties knew my background, I assume, and there's no secret about my associations. So there was no application for my recusal. I did not feel conflicted. And this is the thing about the law. You focus on the law, nothing else matters.
Ma'am, the public court doesn't only belong to the litigants and you. It belongs to us. And whether Zuma was happy with you, maybe he thought because you had lunch, you can deliver something. I don't know. That's why he didn't object you. I don't know why Hanagom didn't object you. But I'm saying, we, the public, coming to hear now that you had a lunch with Zuma and you didn't have the courtesy to tell the public that is also interested in the matter, that please, if it comes across one day that I went to Nkandla to have lunch with Mr. Zuma, please be aware I did. Don't you think in the judicial wisdom, it was necessary to take us, the public, into confidence?
Ms. Malema, if I did not mention here that I had lunch with Mr. Zuma, very few people would know about it. I don't mind the public knowing. And I'm happy to disclose everything about my relationship with Mr. Zuma or anyone else you want to ask me about. But so here I am disclosing, and if I had something to hide, you should be worried.
Again, you're not answering my question, because I'm talking about a case, and that case even involves monies that people are going to have to pay. I'm not talking about these proceedings. I'm saying in the judicial wisdom that you claim to possess and you want to go to the highest court. Don't you think on a higher side now, you should have made us aware, not because you want to go to the constitutional court, but in your execution of your duties honestly, that because this is a high profile case, it involves high profile people, please be aware that I had lunch with Mr. Zuma, or put differently, do you know what it was going to cost if someone had leaked your picture with Zuma during lunch after hearing that matter, even before you delivered judgment? But remember, this is the judge who just had lunch with Zuma before hearing the matter of President Zuma. Do you know what damage was that going to do to the judiciary? Worse if you didn't declare. Because if it comes through other sources, it's like a breaking story. But if it is declared by you, it's fine, it's well and good, it's clear, you have nothing to hide.
Well, that's what I thought I was doing. I mean, I didn't have to declare, but as I said, I was on official duty with Mr. Zuma. And if a picture appeared on social media, it wasn't a problem, because that's what social media does. And whoever wants to spin a story around it would. It's a question of to what extent we buckle under the pressure of social media, and to what extent decision makers are able to separate the noise from the reality. Which brings me to reminds me of another book, Mr. Malema. It's a book titled Tough Cases. And a group of judges in America got together and wrote about their tough cases. One of the tough cases, and if you Google now Elan Cuba, you will see that that was one of the toughest cases of the judge presiding in that matter. It was a case of this youngster who escaped with his mother from Cuba, and the American court, that this particular judge sitting alone had to make a decision about that, where that child's custody lay. It became an international debacle, with the media camping on the child, where the child was living, and the judge had to cut out the noise of the public on the issue and focus on the law. It gets tougher and tougher to focus on what we are meant to when there is this noise in the media, these allegations. I hope I've answered you.
No, you didn't. Chief Justice, I'll move. What is Morogoro Consultative Conference? Whose consultative conference is this one?
I think there's an ANC Morogoro conference that Kalinicus refers to in her book.
So a judge quotes a political party's conference document in a judgment. What do you call that if it's not a judicial capture?
Are you referring to Tamba's?
Yes, Morogoro. You are quoting Tambo's closing address of a political party gathering in a judgment that belongs to me. It's not your judgment. Once you pass it, it is the judgments of our courts. And I must also quote it confidently and rely on it. But it's quoting a political speech given in a political party gathering, not Mandela's speech given at the Union Building, accepting to be a president of the Republic of South Africa. The two are different. This is a political party gathering. You confidently open a judgment with it. What do we call this?
Well, as I explained earlier, that I quoted that because that is the president of the litigants before me. And if I didn't make sense in my judgment, and I did say to them in the judgment that this is a conflict over which I have no reach. And so by quoting that, I was alerting them to their president, and hopefully they would listen to their president, look to themselves to see how they could overcome their conflicts. So I quoted it from literature. It's a biography of the president of the ANC. So it wasn't meant for anybody else. It was meant for the parties.
Judge, you knew what you were doing is incorrect. That's why you didn't write. It is called, I asked you deliberately because I know it. It is called ANC Morogoro Consultative Conference. And you knew that it will be inappropriate for you to quote ANC documents in your judgment. You deliberately omit the ANC so that people will not even know that a judge of a neutral court quotes a political party gathering documents in her own judgment. Yet we must still perceive you to be a neutral and objective judge who's not biased. Judge, I'm going to argue in this in a closed session, that you are nothing but a political activist. You are no judge and you deserve no high office. If anything, you also factional and belong to Pravin's faction, and you are pursuing factional battles using the bench. Will I be fair in that criticism?
No, you won't. For your information, Mr. Malema, I refused leave to appeal in the Hanukkah matter. It went to the Supreme Court of Appeal, who refused the petition. It went to the Constitutional Court, and the Chief Justice also was party to the decision refusing leave to appeal. So if I misbehaved in any way, there was every opportunity for the court sitting over me to call me to order.
Thank you, Chief Justice, and thank you, Judge. Thank you, Chief Justice, for being patient. It was necessary.
Thank you, Honorable Malema. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Judge, I want to take you back to the time when you were talking about the work that you have done. And as you know, the Constitution requires courts, when interpreting any legislation and when developing the common law and the customary law, to promote the spirit, purport, and objects of the Bill of Rights. What has been your experience in specialist courts or when dealing with commercial matters? What has been your observance of how the judges are dealing with this constitutional obligation? And can you point to cases that you wrote that reflects your observances of this important constitutional obligation?
I try as much as I possibly can to find a constitutional angle to the cases I'm deciding. But for most practitioners, the Constitution, they practice law as if the Constitution doesn't exist, as I said earlier on. And the only time they start looking to the Constitution when they try to scrape the barrel for a ground to appear before the Constitutional Court. And as I said, you got to flip through the Constitutional Court judgments to see how often this happens. We don't have enough or strong constitutional consciousness or culture. And part of the writing project that I promote and support is aimed at encouraging that consciousness, because I think if people write, then the hope is that they would also act in the public interest. And so the topic is not just on any competition, not just on any constitutional issue. It's on public interest issues. So I don't know whether I've answered or whether you want me to go on.
It's fine, Judge. The one issue was to point out the cases that you wrote where you reflect your observance of this obligation. Chief Justice, if I may, just on the issue of the competition that you have encouraged, I wanted to find out, following your address, I think at one of the universities, to encourage law students to practice public interest law. Have you been following up to see if that challenge has been taken by law students? Because it is an issue that I'm particularly interested in, to see that young people actually do practice in public interest law.
Yes, in fact, many articles actually come from the women. And incidentally, the last winner of the UCT award had a publication in Muslim News, which was a circulation, a national circulation. And it was an article accessible to ordinary people. You know, Muslim News is a newspaper. And we awarded that. And she was the attorney. She was now an advocate, and she was the attorney who brought the Daniels case to the Constitutional Court. And she presented the article on Muslim women's rights on death of a spouse, and we had an American interlocutor to take her through her paper and make the presentation, which went very well. So most of the writers are in fact women. And we had a transgender who was the winner of the first award, and his topic was toilet space. So it's developmental.
Thank you, Judge. Thank you, CJ.
Thank you.
Thank you, Commissioner Tsepe. Honorable Minister.
Thank you very much, CJ and Judge Pillay.
Thank you, Minister.
My first question is it, to your understanding, the first time that an ANC policy document or speech is quoted by the courts in delivering its judgment by yourself? I remember reading a judgment. It's just that I can't remember whether it was at the Concord or it's at the Gauteng High Court, where the court quoted the ready to govern document of the ANC with regard to the intention of establishing a Chapter 9 institution, which is the Office of the Public Protector.
You're probably right. I know of no rule and no rule of law that says you can't quote from any particular document. And of course, Kalinikos is an authorized biography. It's a fairly reliable source from that point of view.
So it will not be inconceivable that in assisting the courts to sometimes understand the intentions of the legislature, you may go to the policy views of the governing party.
In fact, in the early judgments, if I recall, there would be extensive references to the Freedom Charter. And I suppose in the certification judgment, there would have been references from from the charter there. Academics write about the Freedom Charter as being the source from which the rights emerge in the Constitution.
Oh, okay. No, that's fine. Does the perception of bias with regards to your shareholding in various investment and so forth
worries you, particularly in the eyes of the public? Because I think what is important is what also the public think about this issue of bias, whether it's real or perceived.
Nobody's raised this issue with me for the past 10 years. And it's been there out in the public domain. And more recently, we've had to disclose all our interests and so on. And the media made a spectacle of my assets. And that's just par for the course. It's open for anyone to inspect, and anyone who feels uncomfortable, as I said, there's a process. Raise your concerns. Quite frankly, it's a nuisance to have to manage these assets, and to park it off in a place that I don't have to think about it is an easier option.
I can confirm that it's true that there is that register of interest for judges. Do you think it does, the fact that judges sometimes could have their interest housed somewhere in trust or in investment companies and so forth, affect the issue of bias, particularly in the public perception for the job that they do on a day-to-day?
Minister, I consciously avoid putting myself in positions that are likely to disqualify me from hearing cases. It means that you isolate yourself increasingly, and particularly now in the Constitutional Court, this is ever more so. Because so many of the issues are issues in which the public have an interest. And when I joined Cancer, I had to think carefully about joining this organization. And I decided to join them because of the public interest value that they serve, and to bring my skills and experience to that board. But Cancer is one of those organizations that's not litigious, as far as I can see. And if there's any litigation against it, I will not be able to participate. Similarly, I mean, some people think it's an anomaly that a judge serves on the IEC. And of course, I cannot preside in any matter in which the IEC is a party. But I don't have any interests otherwise where I can disqualify myself from presiding. Certainly, if someone who is a friend of mine who appears in person, but who that person also holds an official position, if that person appears in person about a divorce or something like that, I'd probably remove myself. But in an official position, then it's just that, an official position. We interact in different ways, and I don't see any reason for removing myself.
What is the impact of the allegations that are made against the judiciary to yourself as a judge in person? I mean, even your colleagues, including the institution of the court itself, if those allegations are not put to a process of investigation and of giving you as a judge or the institution of the court an opportunity to respond to these allegations. And these allegations are perpetually made in the public platforms, in social media, and all kind of platforms that are available.
Well, as I said, Minister, we as individual judges can't react. It's the institution, our leaders, those who value the judiciary as an institution, the protectors of the judiciary. It's up to the institutions to defend us for their own sakes and for the sake of our institution, the judiciary. As I said, this is one of two institutions holding up the democracy. And there's a risk if it's not defended effectively, then we are going to slide. There's and there's instances of when women become vocal, powerful, influential, not just here, but in my election work, there was a case of a woman who was a frontrunner in an election, and 2 weeks before the elections, they somebody put out a media statement saying that she was seen in a parked car late at night with a man, and that destroyed her election campaign, and she had to join forces with another incumbent. But these false statements are hugely damaging. And they damage also not the person targeted, but the institutions. And as I said, the failure of institutions is a symptom of constitutional rot.
Do you have maybe examples of countries where this like could have happened and led to this constitutional crisis or mayhem or whatever that could arise, as you started earlier on when you started with your presentation?
I don't have personal knowledge. Like everybody else, I read in the newspapers that that our neighbors have had issues of a constitutional nature of one sort or the other with the judiciary. There's the Judicial Institute for Africa, which publishes the travails of judges in Africa on a weekly basis, and that publication is housed at UCT, and I can't remember offhand of a more specific case, but I think, and I don't think it's right for me to mention the country, but there was a country where the Chief Justice was hounded, delegations sent to her by politicians, sent to her doorstep, and she was on the run. And the chair of an election management body in Africa had a similar experience, had to pack up and scoot to another country under cover of darkness. So election management bodies and the judiciary are threatened species. So we really need to be careful.
On one of the tasks that you said you have done was this issue of arbitration on various matters by private parties. One of the criticism I read about and get from practicing attorneys and advocates they raise about the private arbitration is that sometimes it denies the courts an opportunity to develop jurisprudence, and as a result, in our country there's paucity of commercial jurisprudence, and there could also be some kind of a designed, deliberate obfuscation of the role of the court in dealing with commercial disputes. That's why most of them, they end up with the arbitration, although sometimes they could go for review, but the courts are really, in most cases, denied an opportunity to develop this jurisprudence. What is your view to that criticism that comes out from time to time?
Oh, that observation, Minister, you're absolutely right. I mean, the observation is true. If you look at the court roll, trial court roll, JP Mlamba will bear me out here, certainly in Durban, bulk of the cases would be road accident fund cases or claims against the MEC or the Minister of Police for malpractices of one sort or another. The state is usually the other party. The commercial disputes have been disappearing from the roll. The motion court is full of claims by banks claiming against unpaid debt. You hardly ever have a commercial dispute in which you can get your teeth in. The most likely commercial dispute you will get is probably where there's an imbalance and the weaker party can't afford the costs of the arbitration, and then you would get a commercial dispute in those circumstances. But absolutely right.
So what do you think should be done to help this kind of a situation?
I heard along the corridors that a certain JP has been recruiting judges to his division to bolster the commercial experience on the bench, so that practitioners are attracted to bring their matters to that court. And that is one thing that can happen.
Thank you, CJ.
Thank you, Minister. JP Mlambo?
Thank you very much, Chief Justice. The first question I want to ask you, Judge Pillay, is the main litigants in our courts today. I think you dealt with them in the last question from the Minister. It's the government and state entities. It's the banks and it's the RAF. Those are the main litigants in our courts.
Yes.
Insofar as the banks are concerned, their main area, I think you alluded to it, is foreclosure. Who stood up and introduced directives to curb the trends that banks had developed when they embarked on foreclosure applications against financially depressed litigants?
Was it? Yes?
Who was it?
It's the judiciary. The judges actually set benchmarks on a number of fronts. That foreclosure, firstly, the Constitutional Court and the right to property to start with, that if there was, if the foreclosure was of a property in which there was children and it was a primary residence, then there had to be better arrangements made before there could be foreclosure.
Yeah, but it's the judiciary.
It's the judiciary
that stopped that racket.
Yes.
Thank you. You wrote a dissenting judgment. I'm just changing the subject a bit. A dissenting judgment in that matter penned by Judge Steyn, in which Judge Nkosi concurred regarding the role of Section 342A of the Criminal Procedure Act. I'm asking you this question simply for you to explain, and I don't want you to give a long explanation, why you dissented, which Judge Steyn criticized as a constitutional analysis rather than dealing with the facts. But am I correct that Section 342A is one of the most effective tools in the hands of judicial officers to prevent backlogs and delays in litigation?
Absolutely. It was a very difficult decision and probably took me the longest to write, because the majority in my division was held the view that Steyn J was espousing. And the magistrate's court, in this case was in the magistrate's court for 8 years. There still hadn't been a plea. There was all kinds of delaying tactics. And finally, the there was an application for a stay of prosecution in the magistrate's court brought by this litigant in that court. And then there's a challenge now. Why did that court assume jurisdiction? Well, the parties brought the case before that court, and it boiled down to an interpretation of Section 324A and a constitutional interpretation. And I think the trap that my colleague found herself in was the notion of subsidiarity. And she cited a professor who's for that authority, Professor Statler, a very nice professor who participated with us in the Detainees Parents Committee, but that's an aside. His textbook was out of date.
Yeah, but I think the long and the short of it all is you buttressed the importance of the section.
Yep.
Especially regarding the history of that matter. Right. My last question, you can respond if you want to. And I'm sorry, CJ, it's the third one. How feasible is it for all judges in South Africa to close all their bank accounts, to receive their salaries in cash, and if they have anything left, to store that cash in their houses?
I think that's a rhetorical question.
Thank you, Chief Justice. No further questions.
Thank you, Honorable Kaba.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon, Commissioner Kaba.
Thanks. I must say that I am impressed by your calmness and the clarity of answers. Now, coming to the question. In Westwood Insurance Brokers versus eThekwini municipality, you handed down a judgment, I think it's your judgment, in which you held municipal officials personally liable for the cost of litigation.
I tried to.
And your ruling is a sequel to other rulings holding government officials personally liable for cost. That the courts are intervening in this way, does it not suggest that our laws are not tight enough, or the law enforcement agencies are not doing their work? What has been your experience?
Thank you for that question, Commissioner. I think I should explain what Westwood was all about. And it was in the context of procurement law. And procurement law is one of the tightest systems we have. There's like 4 tiers of checks. And if you don't meet the first baseline check, if you don't produce a tax certificate, or if you don't meet the requirements, if you don't fill the form properly, you're out. So Westwood is the most extraordinary procurement decision I have ever encountered. And we talk about changing the laws, but I think there's a human hand at work here that needs to be visited. So what was this case about? The case was that eThekwini had put out a tender for water insurance. The requirements were that the tenderers must produce a certificate of being registered on the Financial Services Board, and they must be South African companies. But most importantly, must be capable of providing water insurance. So when the matter came to me as an urgent, they had more or less agreed, the parties, to a setting aside of the award. And they wanted me to make the decision. But council had failed to realize that, and the setting aside was on the basis that they were not members of the Financial Services Board or registered in South Africa. 2 facts you just had to Google to establish. The third fact, when I scrutinized the papers, it wasn't provision of water insurance. It was provision of professional indemnity insurance, which means that when doctors and lawyers malpractice, that was the insurance for that purpose, not for the leaking pipes in the townships and so on. And so what would happen if I didn't step in? So this is a situation where judges are careful about stepping in and making a decision for the decision maker, which would have been eThekwini. But I left the incumbent who had the business to continue providing that service, because what would happen is that the township houses where we paid 5 or 10 rands as part of our bills would then have to provide their own insurance, and they don't even know how to get private insurance. And if there's in a drought situation, the water is wasted. It's a calamity. So that ended the substantive dispute, but there's a question of costs. And I could not understand how in all this pleading, there was no explanation for how this error came about. There were legal advisors involved in the process. There was one youngster in the administration who put out a report to say this tender shouldn't go through. And they disregarded that voice. It went through 4 tiers. At the 4th tier, there's a legal advisor, there's engineers with tertiary degrees. How did they miss this? And so I thought I needed an explanation. I didn't think that eThekwini should use taxpayers' monies to settle the applicant's bill. And so I called on the city, please tell the court who are the people involved. And then I got a list of names. And then I wrote another judgment and said, a directive to say, will each of these persons give an explanation for how it came about? The legal advisor gave an explanation and pleaded to whoever was prepared to listen that she had very little time to prepare this. There was a little error, but she doesn't tell me what the error is. But if they simply said, we messed up, we made a mistake, we are sorry, that would have been the end of the matter. There was no explanation, which is what disturbed me so deeply. And that's why I said, well, if there is no explanation, then I can't absolve you from costs. And so I distributed costs, half the cost equally among 16 people. And regrettably, I granted leave to appeal, but the city funded the application for leave to appeal. The net result of that judgment is that we have the city paying double costs and the officials are absolved. We don't know what happened, and it's not the first case of its kind.
Thank you very much. What do you say to those who feel that this intervention by the courts may have unintended consequences? Like, for instance, where officials may fear may be afraid to take decisions for fear that they may be held personally liable at the end of the day. I'm not one of those, but I'm just raising it. Thanks.
Oh, well, I think you'll find my explanation in my judgment, because that's a countervailing consideration. You don't want to. People make mistakes. I mean, we're humans. In the ISE, we've made a couple of mistakes. So the thing is to own up, give an explanation, be bona fide, and nobody's going to impose a cost. It's a very high threshold to meet to impose a cost order on a public official. We're public officials.
Thank you very much. CJ, thanks, Judge.
Thank you, Honorable Baba. Justice Pillay, I have a few questions for you too.
Yes, Chief Justice.
I noticed when Honorable Singh asked you, flowing from the comments that he read, whether you were a friend or a close acquaintance of Mr. Haneko and Minister Godam. You said, with respect to Mr. Haneko, no, I'm not his friend. And then with regard to Minister Godam, you said, do I know Mr. Godam? Yes, I know Mr. Godam. There is no way I could not know him. It was after Mr. Honorable Malema asked you in a more pointed way, again, whether you were friends, that you admitted friendship. Let me tell you where I'm going to. During the last interviews for the Constitutional Court that you attended, and while the JSC program was running, my office got a call from the office of Minister Pravin Godam seeking an appointment with me. And I was a bit surprised. We had never met except at the meeting of the heads of the arms of the state, where he had to brief us as Minister of Finance regarding the true state of the fiscus at the time, so that we embark on the cost-cutting measures that you might be aware we tried to introduce afterwards. He came, I took a break from the JSC proceedings, and I really don't know what the purpose of the meeting was. I don't have a clear recollection. I think there was something about the tax ombuds, but what stuck to my mind and left me puzzled was the following. He asked me a question. He said, how did my friend Daya Pillay perform? And we had just caused the spokespersons to announce the results, and I told him, because it was public knowledge, that you did not make it. And the thing has stayed with me. It got renewed as Honorable Sim read the question to you, as Honorable Malema engaged you and said, why did the Honorable Minister make an effort to meet me? We are not friends. I don't know him from anywhere except from television. Why did he make a trip, seek an audience with me, just to ask me, how did my friend Daya Pillay perform? So it is in that context that the concern regarding your relationship with Honorable Minister Godam arises, and my concern regarding your initial response, which didn't seem to admit or acknowledge friendship, arises. Now, I'll put to you what others have probably put to you, so that you can deal with it and be satisfied that you've dealt with it. It doesn't have to be a long answer. Is it potentially compromising to judicial independence and impartiality. For a minister or a senior politician to be keenly interested in the upward mobility, or to look like he or she is keenly interested in the upward mobility of a judge. And let me explain, I'm raising it because you remember there was an issue about friendship between a politician and a judge not so long ago. It seems to be an issue. That's why I want you to deal with it. Just in your own ways, just deal with it as briefly as you can without compromising the quality of your answer.
Chief Justice, I wasn't aware of this interaction between you and Mr. Gordon, Minister Gordon.
I believe you.
Thank you. And from what you tell me, it seems as though the decision had already been made about my...
But he wasn't aware. But he wasn't aware that it was made.
Sorry, he wasn't aware, you say?
No, he wasn't.
Yes, but so my next question for clarification, Chief Justice, from what I gather you say is that he simply asked, how did my friend do? Did he say anything like you should appoint her or anything like that?
No, he didn't.
Okay, so I would imagine that it must have been in the course of whatever else he was doing with you, it came up as casual conversation. This was the gathering in Cape Town, if I recall.
There was a gathering in Cape Town, and as soon as he asked the question, I immediately gave him a response. He didn't make it.
And then, but that was a gathering I remember where my interview was supposed to be on the Tuesday, and I was phoned on the Monday morning after having celebrated Judge Thamba Pillay's 80th birthday. And I was hoping to recover from that on Monday and make my way to Cape Town, but I was interviewed that evening, late in the evening. So, but the reason for that, I understood, was that there was a big thing going on with the Minister of Justice, with the Minister of Finance, but there was something else that had to be that compromised the JSC hearings, and we had to shrink it into the first day. But there was some other big thing happening that time. But so I'm assuming that he must have called you about that. I don't know what he called you about. And I know that Mr. Gordon would not promote me or any of his friends precisely because of his high profile and the fact that he would be accused of this. That's the extent to which I know. Whether he's, I certainly wouldn't rely on him to promote me at all. And as far as our relationship has been, our boundaries have been strictly observed. I can only imagine that he asked you in passing in relation to the other business. And I think he was disclosing to you that he was my friend, which is no secret.
Okay. Now, the next question is yesterday, and I think it's fair that the question be put to you as well. Our colleague, Judge Kolapen, was asked, given your age, if you were to be appointed, you won't be able to serve the full term. And that applies to you too, because you're only 7 months and 20 days younger than him. You will therefore, one, if appointed, qualify for a higher salary. Two, but then not serve at the full period of a constitutional court justice and retire with a higher salary in circumstances where another candidate who would have given us the full length of the period would thereby have benefited the state for a much longer period. I know it's a difficult and unfair question to ask, but let me ask it anyway. Given the financial challenges, the budgetary constraints under which our government operates, the state operates, does it accord with cost efficiency to, or is it cost effectiveness? Sometimes English escapes me. Does it accord with the commitment to manage our resources as parsimoniously as circumstances dictate? That you appoint somebody who's not going to give you the service for the full period recommended, have the person retire and get that higher salary for the rest of the life, is his or her life, in circumstances where another candidate would have served us for the full term.
Well, Chief Justice, you know, the applications have been delayed because I applied last year. You'd have got an extra year's service if I was appointed and this process had moved on. But I retire in 2 years otherwise. And I retire with full pay, which means that I will be minding my potatoes in my backyard earning a state salary, even if it is for less than the judge's salary by about 10,000-15,000 or whatever. But that's the one thing to think about. The other is the cost of effective dispute resolution. Now, I think Dan Glodlow, our colleague, gave the best answer to that question, the age question. He says a ripe lemon is much sweeter than a sour one. And to miss out on the experience that I bring, the possibilities of scholarship and rendering decisions that have a wider acceptance. So the cost of effective dispute resolution on the one hand, and the savings that you make of 15,000 per month or whatever it is must be balanced, and that's a decision that the Commission must make.
Now, the issue about attacks, your comments on the attacks on the judges, I think we need to go through that. One, you're aware that you and I and other judges discussed the issue of attacks against the judiciary. And I remember in your own comments saying, while we were discussing it, you can only succeed in giving airtime, undeserved airtime, to this kind of remarks if you're going to comment or respond as the judiciary. So I'm raising it because I heard you raise what I thought was a concern about the need for the leadership of the judiciary to protect the judges. Do you now think that it's necessary to respond, contrary to what you had earlier said to me and to other colleagues?
Absolutely not.
When we had, all right, okay.
Absolutely not.
And of course, the issue of allegations that you are on the CR17 list, which is something that has been said of a number of other colleagues, that they are on the CR17 pay list, can only be resolved if the document that allegedly contains the names of people who were paid were to be made known to us. But for as long as we don't have access to that document, there is no way in which one can be able to say, but it's a lie. Judge so-and-so is not on that list. I have seen it. As long as we don't know what is on the list and you issue a public statement, what are you going to say? Are you going to say he or she is on the list or not? We don't know.
Yeah.
Is that not so?
Absolutely. Chief Justice, just to go back to your earlier point, there was a reason why we, as a collective, took the decision not to make a statement as a judiciary at that point in time. But earlier, in response to the attacks after the warrant of arrest order, the court did make a statement. Our DJP did issue a statement. So when I say that the question was asked, what should we do? And I was saying that the leadership, the judiciary needs to defend the institution. It was an observation and it wasn't a criticism. And I stand by the decision we took, and I won't say why. We took the decision we did, that there won't be a statement issued at that time. I fully endorse it.
And of course, you're aware that when judges in provincial divisions or specialist courts are attacked, it becomes the responsibility of the leader of that court to liaise with the spokesperson for the judiciary to craft the statement that could then be issued on behalf of the division, rather than the Chief Justice trying to get involved in everything as if there are no leaders, as if there are no competent leaders to handle such matters.
Well, that was exactly what was done. The DJP issued a statement.
Yes. Thank you very much, Justice Pillay.
Thank you very much, Chief Justice, Commissioners.